which is in active service in any place. B, where while serving in defense force under the engagement by which he or she has agreed to be subject to military law. C, where the person is in unlawful possession of arms, ammunition, equipment, ordinarily being a monopoly of the defense force, prescribed in Schedule 7A of this Act, or classified as stores prescribed in Schedule 7B to this Act, commits an offense under any written law. D, where the person aids or abets a person subject to military law in the commission or conspires with a person subject to military law to commit the offenses. The offenses below: 1, murder; 2, aggravated robbery; 3, kidnap with intent to murder; treason, prison of treason, or cattle rustling. E, where the person without authority is found in possession of or sells or wears a uniform of the defense forces, or where the person is found in unlawful possession of arms, ammunition, or equipment ordinarily belonging to the monopoly of the defense force, prescribed in Schedule 7A of this Act, or classified stores as prescribed in Schedule 7B of this Act. G, where a person is serving in position of an officer or a militant of any force raised and maintained outside Uganda and accompanied by the officer of the defense force. The above clause is an attempt to reenact Section 117 of the Updf Act, which was struck down by the Supreme Court for offending Article 28(1), 44C, 128(1) of the Constitution. Such is inimical to the rule of law, good governance, which is a cornerstone of democratic dispersion, and that of other civilized nations and communities across the globe. It also constitutes an egregious attack on judicial independence, thereby contradicting Article 28(2) and 3 of the Constitution, which provides that no person or authority shall interfere with the courts or judicial officers in the exercise of judicial functions, and that all organs and agencies of the state shall accord to the courts such assistance as may be required to ensure effectiveness of the courts. See Article 28(2) and 3 of the Constitution. This action amounts to contempt of the Supreme Court, which is criminal, a path that must be avoided by a decent parliament. Right Honourable Speaker, in a locus classicus case...
Do you have to ask to add a decent parliament? Must you add decent? Nobody doubts that we are decent.
Avoided by our parliament.
So
most obliged.
Expand the word decent.
In the locus classicus case of Liange versus the Queen, 1967, the Sri Lanka Parliament passed a retrospective law affecting the trial of individual accused of attempted coup. The Privy Council struck down the law on account that it sought to alter the course of a particular decision and effectively overturn the jurisdiction. The Indian Supreme Court in Indira Nehru Gandhi versus Raja Nara in 1975 SC 2299, after election was invalidated by the High Court constitutional amendment that was passed to validate the election. The Supreme Court struck the amendment, holding that the Parliament cannot enact legislation that overturns specific judicial decisions. Any legislation passed with the object of annulling the effect of a judicial decision has been held to be an encroachment on the judicial powers, and it is unconstitutional. Your Honor, coming down, there were other authorities that, Right Honorable Speaker, rather, and colleagues, there were other authorities that were cited year after to persuade the House. I had members to peruse through while I go to deal with the second area of dissent. The second area of dissent is illegality in military trials. Your Honor, Right Honorable Speaker, the question of illegality in military trial is ably canvassed by the Supreme Court in the case of Michael Kabaziruka in the above case. Owindolo CJ, in his lead judgment at page 180 and to 185, had this to say, Your Right Honorable Speaker. There are also other vital reasons militating against trials of persons subject to military law for all offenses. These courts has previously held that there are certain offenses that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to a specific court. It would therefore be wrong for Parliament to cause a conflict by conferring on court-martial jurisdiction to try such offenses. For instance, since terrorism can only be tried by the High Court, which is an ordinarily civil court.
Honorable Court Junior.
Yes, Your Honor.
Honorable Justice, Chief Justice Owindolo had this to say. Open court, and then you close the court. Somebody will imagine
Most obliged.
that it continues up to the end.
Most obliged.
Close the court
Honorable
first.
Speaker. And if I may proceed from where I had stopped, Right Honorable Speaker.
For clarity, say what Chief Justice said, open court, close it, then you bring your statement.
Right Honorable Speaker, the CJ, Justice Owindolo, in his lead judgment at page 180 to 185, had this to say. Open court. There are also other vital reasons militating against trials of persons subject to military law for all offenses. This court has previously held that there are certain offenses that are not triable by the court-martial. This is so where a particular act grants jurisdiction under it only to a specific court. It would therefore be wrong for Parliament to cause a conflict by conferring on a court-martial jurisdiction to try such an offense. For instance, since terrorism can only be tried by High Court, which is an ordinary or civil court, it would be contradictory to try it in the military court as well. And also it would be self-defeating for an offense similar to terrorism to be created under the Updf Act and then the persons are tried under it, close quote. I find this holding by Mulenga by Justice of the Supreme Court, Justice Mulenga, still correct position of the law, and where jurisdiction is expressly excluded, or where the DPP's consent is a prerequisite, the court martial are not competent to handle that matter, so excluded, irrespective of the provision to the contrary. Under the impugned section 1 and 117I, G and H of the UPDF Act, it amounts to duplication to grant jurisdiction to the court martial over it when, owing to the gravity of these offences, Parliament conferred jurisdiction over them to ordinary courts. The other issue for consideration is the danger possessed by concurrent jurisdiction, where the military courts that is also before an ordinary. This would necessitate the establishment of a mechanism between the court martial and the DPP to manage the cases beyond mere provisions in the UPDF Act, and the jurisdiction of the court martial does not take away that of the civil court. Concurrent trials in both military and ordinary courts for civil offences would also be prejudicial to an accused for a simple reason that it could lead to double jeopardy, as each court could potentially come up with a guilty verdict. Additionally, as already noted, the General Court Martial and other military courts are subordinate courts. See, in Justice Mulenga's finding, where I held that the General Court Martial is subordinate but not lower than the Court Martial. According to the Black Laws Dictionary, Brian A. Garner, 8th edition, subordinate means placed in or belonging to a lower rank or class or position, or subject to another authority or control. Assigning an ordinary meaning to the word subordinate, all court martials as subordinate courts created under Article 129(1)(d) can only have jurisdiction that is lower than the High Court. Saying that it is subordinate but not lower than that of the High Court is contradictory and has the potential to create an absurdity when it comes to hearing of capital offences. If Parliament desires to grant them the jurisdiction to handle capital cases, then it would need to do so in line with the Constitution. I will return to this later in advisory opinion to explore the options that could be undertaken by Parliament to achieve this effect constitutionally. With this finding, the hearing by all court-martials of offences within the jurisdiction of the court-martial is unconstitutional under Article 28(1), 44C, 128(1), 129D. Close quote. The general rule is that ordinary courts alone have jurisdiction to try civilians. The Supreme Court was unable to find any rational justifiable link between the need to maintain discipline in the army or maintenance of security of Ugandan borders and trials of civilians in the military court tribunals generally. However, having held as above, the Chief Justice made the following orders. A. The provisions of 179, 1, 2, and now 171, 1 and 2 of the UPDF Act.
Is it 171 or 177, 1 and 2?
179, 1, and then 1 and 2, and then 177, 1 and 2 of the UPDF Act. Read together with 197.2 and now 197.2, which grants subordinate military courts jurisdiction over capital offences, contravenes Article 129, 1D and Article 126, 1 of the Constitution. Hence, they are unconstitutional. The provisions of Section 119, 1I and G, now 117(1) and G is unconstitutional to the extent that it permits trials in court-martials of civilians who allegedly aided and abetted the commission of service offences or ordinary criminal offences in which a person subject to military law is a principal offender. Right Honourable Speaker, the minority observes, I'll jump D, the minority observes that the Supreme Court's decision had the following effects. The trial of civilians by court is only permissible in exceptional circumstances and only after state has concretely demonstrated to court by verifiable facts and by objective and serious reasons, need and justification for a recourse to a military court. 2. The minority observed that military courts can only have jurisdiction in relation to specific class or category of persons and specific offences which ordinary courts are not in position to try. 3. The jurisdiction of the court-martial can only extend to cases reserved for specialized courts such as Anti-Corruption Court under the Anti-Corruption Act, International Crimes Division under the Anti-Terrorism Act. 4. Military courts cannot have jurisdiction of offences which require the consent of the DPP. The consent of the DPP. 5. Civilians cannot commit or be tried for service offences even when they abet or aid the commission of offences. 6. Where civilian and military personnel have committed a crime other than a service offence, both be tried in civil courts. And 7, Parliament cannot duplicate offences prescribed in other acts of Parliament to introduce them in the UPDF Act. Colleagues, members of Parliament, the ratio from the above, with a sober appreciation of the provisions of Article 28 of the Constitution, leads to inevitable and incontrovertible conclusion that all persons, militant or otherwise facing criminal trials, have a right to appear before a competent independent, fair, impartial court or a tribunal. With a decision of the Supreme Court, the trial of persons with offences within the exclusive jurisdiction of the civil courts, particularly by the High Court. Military courts are not competent to try such cases. It goes, therefore, without saying that any trial will still be unconstitutional and will offend the principles of a fair trial. Accordingly, enacting the proposed legislation into law will be a legislation in vain. Common theme among justices of the Supreme Court Common themes among the justices of the Supreme Court was that the General Court Martial is a tribunal and should be kept as such. Right Honourable Speaker and members, let me conclude on this note. Court martials should be specialized disciplinary tribunals with restrictive functions to handle disciplinary matters that are peculiar to and connected with discipline and regulations of the armed forces. But Justice Catherine Bamugemere, Justice of the Supreme Court, at page 41 of our judgment. Colleagues, members of Parliament, having appreciated that the second area of dissent has been appreciated, I would go to
the third area of dissent.
Your Honor, Right Honourable Speaker, offending the doctrine of separation of powers. Modern democracies are typically organized around three branches of government. Any of the other two would inevitably offend the Constitution. The judgment of the Supreme Court covers situations where military under the Updf Act may depart from this position by only in a very exceptional circumstance that are consistent with demonstrable justification. The chief, page 78 to 79, quoting Naluero in his work, Improving the Administration of Justice by Military, an appraisal of the jurisprudence on human and people's rights, 2019. Held a host of authorities